like to now turn it over to Shawn Brown from our Tampa office. Shawn, take it away.
Thank you, Jeff. Good afternoon, everybody. It's 12:03, so we're actually past the morning. So briefly, a bit about myself, Shawn Brown. I am in the Tampa office of K. Bender Rimbaum. As Jeff noted, I'm a board certified attorney in condominium and plan development law. I am also a member of the board certification committee that's tasked with reviewing applications for those seeking certification and also writing the test for those that are actually granted the opportunity to seek certification. I'm an active member of the Condominium and Plan Development Committee of the Florida Bar, including an immediate past vice chair, and I currently serve as the vice chair of the Real Property and Probate Trust Law Section Real Property Litigation Committee. So I've been around. This is my 20th year of practicing law. It's hard to believe. When I told my mom I've been practicing for 20 years, she kind of wondered where the time went. So the beauty of today is, I've got some brief opening statements, but I want to hear from you. I'm one of those that does not like to have somebody just lecture endlessly. I want to be interactive. I want, questions. The more, the better. I feel that we all benefit from hearing from different events that we've dealt with, different ideas we're thinking of, just different things we've come across. And I want this to be educational, informative. So please don't hesitate to ask questions. I would much rather hear what you guys have to say and is on your mind than just me pontificate for an hour and a half. So with that, I do want to give a couple of brief opening remarks. First, let me say, welcome to 2022. And I think in terms of this year, it's going to be a year of fundamental change for associations, especially those in condominium and cooperatives. We're going to be facing the fallout in the legislative session from the Surfside disaster, and I'm sure we will have many, many bills trying to address that. You also have a continued effort by those of you that are in condominium land of the Department of Business Professional Regulation to continue to have more and more oversight of election issues and what is perceived to be fraud within condominiums themselves. On the election issues, I will note, again, this is only pending legislation. The session hasn't started. It starts next week. Is a potential to allow the state condominium ombudsman the authority to invalidate condominium elections if he reviews it and determines that there are irregularities. So definitely something you're going to want to keep track of and that us in the firm will be keeping a close eye on. We also have, beyond that, we will have the Surfside legislation. It hasn't been introduced yet, but I have a hard time believing that we won't find anything given the amount of time and effort that has been invested in that project itself and determining ways to address it, including potentially, as we've heard about, greater disclosures being provided to unit owners and or prospective purchasers. We have the never-ending issue on estoppels, and also one of the big hot button topics that deals with budgeting specifically will be limiting the ability of owners to waive the reserves, increasing that threshold requirement. Directly tied to that, and one that I think has flown under the radar, is both Fannie Mae and Freddie Mac have announced changes to their condominium and cooperative underwriting guidelines. That's a fancy way of saying if you're buying or selling a condominium unit, the ability of somebody to obtain a loan to finance that purchase may be impacted. So what does that mean here? What that means is that in terms of maintenance, both Fannie and Freddie have revised their underwriting guidelines. Fannie Mae's is effective as of January 1st, so these are already in place. Freddie Mac's takes effect at the end of February 28th. They're going to want to look at deferred maintenance. What's out there? Do you have any critical repairs that need to be addressed beyond just regular maintenance? If you have those, then the project may be ineligible for Fannie and Freddie financing. You also have them looking at the reserve component and no longer being able to rely on reserve studies, but really wanting to take a hard and fast look of, does your association have more than 10% set aside for reserves? If you don't have 10% set aside reserve, that project may also be ineligible for Fannie or Freddie underwriting. And finally, the one that I found fascinating was special assessments. They're going to take a close look at special assessments, including if the assessment on that unit has been paid. And they're going to take a determination of what was the assessment for. Is there a potential financial impact to the association in terms of the ability, if it does not receive the funds, to carry out the repairs? And beyond that, just really diving into the minutia. And this is something, again, that's sort of flown under the radar, but everybody should be aware of, because at some point in time, either you're going to be selling the unit and you're going to be looking for somebody to buy your condominium unit, or you may be looking to buy a second home or have some other investment property. And these are things that we have seen as a result of the tragedy down in Surfside, and the lenders react to it. So while you may be sitting there and saying, I'm complying with everything the state law requires, we've done everything correct, understand that the private market is taking an action, and that if you can't get your project eligible for Fannie or Freddie, then you have the issue of will the lenders underwrite the property. It's something we're going to have to watch unfold, but I wanted to get that out there so everybody's aware of that, because it may be a situation where you're complying with the law, like we've seen with insurance, where you're meeting your requirements. The roof is not needed for repairs yet, it has 10 years left of useful life. But at the same time, the private industry, such as your insurance carrier, is saying, if you don't replace that roof, even though you still have 10 years of useful life left, we're going to modify your insurance or we won't insure you. So please be aware of that, and you may want to be consulting with your attorneys as you go forward this year and understanding these issues, so you don't have your project effectively blacklisted by Fannie Mae and then have to seek an exemption. So with that introduction and giving the horror stories to 2022, only 5 days in, Jeff, what do we have in the hopper for us?
Okay, we have a couple of questions. Actually, we have 8 so far, so type in your questions at any time. Again, please, for those of you just joining us, please be sure they're themed to today's topics, which are association elections, budgeting, maintenance, and reserves. Our first question is, Shawn, what is your stance on having 3 out of the 5 board members attend informational sessions, committee meetings when there is no vote being taken? So that's, our current attorney says it violates okay, that's not really related. Let's get back to that one later. How long can the same person serve on a term? Is the next question. So how long can the same board member serve is what it looks like.
Well, I mean, it's going to depend if we're talking about a condominium or HOA. If your document,
So,
go ahead.
Carol, I'm going to, let me get to Carol here. Carol, I'm going to enable your microphone. We'd like you to elaborate a little bit on that, because the question is not as clear to us here. And it's not working. Carol, let us know in the Q&A if you are a HOA or a condominium association or co-op. Oh, go ahead, Shawn. Sorry for the interruption.
No. So, in an HOA context, is most often with election matters, it defaults to your governing documents. The state has taken a very hands-off approach in terms of regulating homeowner associations. So if you don't have any particular restriction on term limits or such, then happy hunting, and the person can serve in sort of in perpetuity. If you end up on the condominium side of the equation, then you look at the change to the legislation last year, which is that you have an 8-year effective term limit. And so as long as you're within that bounds, and that, as the legislation clarified, that's only prospective. So we're only counting from 2018 forward. So if the person had been serving for 15 years prior to 2018, we're ignoring that and we're going forward. Now, there are some exceptions that allow a person who's been going for 8 years to continue going forward, whether a certain percentage of the membership approves or if there are no candidates. There's also ways we've seen people kind of play fast and loose with it. But in terms of election terms, it's this 8-year term limit. And I don't foresee that being modified any further. And I don't foresee the legislature taking a look at trying to crack down on homeowner associations and have any type of term limits there.
Okay. Thank you for that. And our next question is from another friend here, Mary. If our docs state that a minimum 5-member board and we only have 3 members, they're having difficulty getting others to participate. How many is a quorum of the board for conducting business? 2 or is it 2 or 3 board members? Unfortunately, they seem to be getting different opinions.
Well, I mean, if the docs provide for a 5-member board and there's nothing that changes and there's no flexibility, and it literally says you shall have a board of 5, then you need to have a board of 5. And if you only have 3, then you have 2 open seats within the board and you've not modified it. So unfortunately, it's not, to me, it's not a 2-person gets a quorum. You need 3 out of 5. That's a majority. Again, it really depends on the wording of the documents, and if it clearly says that it's 5 and nothing more, or if there's some wiggle room that allows for some flexibility. So, but based on what the question says, if it truly says there shall be 5 board members and you only have 3, then you need all 3 to conduct business.
Okay. Here's one that is more reserve budgeting related. Edwin wishes us all a good afternoon and happy new year. Thank you, Edwin. Same for you and your loved ones. For an association who has never done a reserve study, will the association be tied to the recommended numbers for future budgets?
I mean, right now, reserve studies are basically advisory opinions, so there's nothing that says by law you're tied to it. If you're going to depart from the numbers in there, and in my mind, it would be more of a downward departure, there should be a justifiable reason for it. The big thing we're all looking at in these days is the ability to avoid liability. We want to be able, and just today, by giving an example of just an issue that came up, I was reading opinions out of the 4th DCA, and there was a homeowner association that left a bollard from the developer and was kind of camouflaged, and a man riding a bike hit it, fell down, fractured his neck, became a quadriplegic. And at the end of the day, there was a $40 million judgment against the association. So the big thing we're all looking for when we see these type of horror stories is how can we avoid liability? And so if you have a reserve study that specifically says, here's these components, you're going to want to track to it as best as possible because you want to rely on the advice of professionals. So if anybody ever accuses you of breaching your fiduciary duty or you're facing a claim, you have the ability to say, look, I did what my job was as a board member. I sought professional advice, I obtained it, and I relied upon it. Now, if it says that, the roof component needs to be reserved at $3 million, and you decide, no, on my own, that we need it to be at $1.5 million, you're going to want to have some justification for it. So in that downward departure, because the thing we're noticing these days is everybody's looking to find ways to pin liability. And as we've come to know with associations and plaintiffs' counsel, associations have insurance policies, and insurance policies like to pay on claims to avoid larger issues such as a $40 million award. So while you're not tied to your reserve study, I would track it as close as possible unless the reserve study comes in and you have another professional opinion that gives you a reason to depart from it.
Good answer. We have a question from Jenny here, and this is another budgetary related question. And it looks like it has to do with contingency accounts. So please explain where contingencies should be posted, operating or reserves.
So contingency to me means a lot of things. So, if we have a way to enable sort of a clarification on what we're talking about with contingencies, are we talking sort of contingent deferred maintenance or contingent accounts that may pay out in terms of delinquencies? Just like to see if we can get a little bit clarification on that.
Hang on here. Let's see, Jenny, you can unmute yourself and you can clarify the question. The mic is open for you, Jenny. You just need to hit unmute. There you go.
Okay, yeah, I was just asking about the contingencies towards operating expenses, not necessarily contingencies on reserve schedules, but basically, should they go like operating expenses that go beyond what we're sort of like a slush fund, I would say. How about that?
I've heard it called that as well.
I mean, it's always fun to give a legal opinion when somebody asks you about a slush fund. But it's 2022 and things are a little different. Now I get it. It's having sort of a rainy day fund. Obviously, my mind, you'd want to have it as some item within, to me, the regular operating budget. Now, when you put together the operating budget, you should have a good idea of what your expenses are going to be in your line item categories. If you're going to have because you call it a slush fund, you want to have a specific line item. And usually I see a lot of associations categorizing it as, sort of a deferred maintenance, kind of a catch-all account. But at the same time, you're supposed to, when you do your budget, be able to say, these are my expenses and budget accurately. So, you're going to want to be very careful with that. If anything, you may want to adjust other accounts of, if your deferred maintenance you're setting aside, say we need 50,000 for the year, you may want to up it there versus creating a catch-all, because the last thing you want to be, in my mind, especially, is if you're saying it should be a slush fund. In an operating budget, the way the law is designed and structured is you're supposed to know your expenses and budget accordingly. And if you have a catch-all contingent, I think you're better off calling it something other than, contingency or something that, just having a general deferred maintenance, something that gives you that cushion so you're not having to go and get a special assessment.
I've seen some associations, Shawn, that had a fund like a contingency fund, and I think it was the documents that said something to the effect of like, the administrator or the CAM or the board has the ability to spend X amount of dollars from this fund up to a certain amount. And if it's above that amount, it has to go to vote. Is that also the same kind of fund?
I've seen, that. I mean, the one thing everybody's concerned about is accurately budgeting, because nobody ever wants to be the person, a board member that says, hey, we need a special assessment, we're short of funds. So obviously you want to build in some wiggle room within the budget, but I think you have to be very careful with what you call it. If you have it as a general contingent fund, my mind, that's sort of not proper budgeting, because you're supposed to have very specific line items pursuant to the statute of what you should have in there. And so rather than building contingent funds, I think the better practice is, if you think you're going to need extra money potentially, just build it into like a deferred maintenance account, or any place where you feel like, we're expecting, $50,000 this year to spend on this project. We're going to have a little bit more on maintenance just to give us some cushion.
Okay. That's great. Thank you for that question. The next question is from Joseph. How significant, and this is election related, how significant are faulty notices for the annual meetings, the agenda, the notice of intent to seek a board position, and time constraints? Can they be corrected? And I guess, when is it too late to be corrected? So what are some of the repercussions if the notices are faulty, late, so on and so forth?
I mean, having just done a presentation with the DBPR, they're very clear that if you miss, your information is incorrect, or your notices are incorrect, that upon a complaint, you run the risk of the state basically invalidating the entire election and having a do-over. Now, if there's an error, or there's some sort of misstatement in there, and you have time to publish a new one before, you haven't hit the magic deadline to send out the second notice or anything of that sort, then if you correct it, the state generally takes a hands-off approach that, the error was out there, but it was corrected timely. But if you have an error and it's one of these fundamental, leaves off something essential, be aware that the state, upon a proper complaint, may come in and validate the entire election, require a complete do-over. And nobody ever likes to have, one, the state looking at their material, nor spend the time, effort, and again, expense of that. So, to my mind, if it depends on your materials and, do you have time to fix the error? And if it is an error, is it something that's, truly fatal, or is it one of these that I like to call a Scrivener's error, where you can argue, look, there's really no harm here. It's it's a minor misspelling of something.
Okay. Our next one is also election related. This person is and you'll know why I'm not mentioning names here, just in case. This person is a new board member at an HOA. Says there's a bit of an anarchy situation happening there, with board members saying that residents are not willing to participate in elections. So the board has the perception of being paralyzed. So do you have any recommendations or have heard of how others have resolved this kind of a stalemate situation in an HOA?
Anarchy in a community association? I never heard of it.
Never.
No, I mean, there's really, if you're trying to drive member participation, I mean, it's really hard. I mean, everybody works, spends, they have just their jobs, their family life, everything else, and then to throw in another commitment. One of the ways, at least I try and address these issues with, board members and then those at the meeting about how to be involved is, think of your association effectively as like Apple, Google, IBM, General Motors. It's a corporation. And that, the goal here is to maximize and increase value. How do you do that? You drive up property values. And how do you do that? You get involved, you get people interested in it. I mean, unfortunately, as you see all too often, a lot of people are just apathetic. And it dissolves into a situation where you get a board where nobody wants to run, so they're continually in power. You get people who are always willing to raise complaints, but aren't willing to step up. The common refrain I always like to tell clients, and when new board members come on who've been, out in the wilderness, for lack of a better term, is it's a lot easier to throw the hand grenades than it is to catch them. So there's no real good one size catches all. I mean, it's really trying to drive home to people that, you bought in here, and as most people, the home is their biggest singular asset, and we all want it to appreciate in value. Nobody wants their home to go down. And the easiest way to do that is you get involved, be active in your association. Again, I really wish I could say, if you did these 5 things, you would double your turnout. The only joking, at least in my line, the way to increase turnout at a meeting is just to call for a special assessment, because then everybody shows up to complain. But unfortunately, that, you can't do that all the time. So, anarchy tends to reign in these, and I think the only way forward is, through education and then disclosure.
I've heard of, there's one association that I do some work with, and just to clarify, I am not an attorney. I'm just moderating this for anybody hearing what I'm about to say. But with one of the associations I work with, they're started to utilize technology to get more resident participation at the meeting to provide input for the board members. So for instance, they're painting the exterior of their building. So they put out an informal survey online, and everybody in the association can go ahead and online and say if they prefer the paint swatches from option A or option B, and then the input gets back to the board. So that, I don't know if that's would fit into that question. That's one example of how the board is getting some of the members who own involved in helping the board make a decision. What do you think about something like that?
I mean, it's one of the things that we see is the use of technology being enabled within community associations. We always hear the jokes in the news about Florida and Florida man, and Florida being its own little backward state. But the legislature has been very technologically forward thinking, whether it comes to in community associations such as condominiums about charging stations or the ability to have natural gas fuel hookups, or whether it's in terms of zero-scape, electronic voting. There's a big increase in the ability to use these type of, like we're doing now, Zoom. Courts have transitioned to a lot of Zoom stuff too. So we're seeing the technology bringing more people into the fore, and those, especially who are out of state or maybe overseas, are more eligible now to come in and see things. So I think that's a benefit to it, but at the same time, you run the risk of, like we've seen in some instances, people who've not really participated suddenly, oh, I got a Zoom link, I can show up, and they raise all kinds of chaos because they're jumping in into matters that have been going on for months. So there are pluses and minuses to technology, but again, in my mind, it helps facilitate that disclosure, and that if the information's getting out there, I think it tends to solve itself in a lot of ways.
Okay. And then before I get to the next question, if we skip over your question, again, we're just trying to keep it topical today to the topics that we advertise on elections, budgeting, maintenance, and reserve. So please don't take it personally if we skip over some of your questions. And we have a lot of you here today, about 100 of you, 100 plus. So in the time that we have here, we'll try to get to as many as we can. So if we don't get to all of them, again, apologizing ahead of time here. Okay, our next question: in an HOA, does a developer, I guess the developer is still involved, have the ability to use the meeting notice and remove notifications from the floor, even though the docs site? Wait, I'm a little confused here. In an HOA, does a developer have the ability to use the condo meeting notice and remove nominations from the floor, even though the docs cite a traditional HOA election process? Should we ask Melanie to elaborate?
Yeah, I mean, that's kind of, I
Hang
get
on a
what
second here. Yeah. Melanie, I am going to. Please,
Can you hear me?
Yes, we can. Thank you, Melanie. The floor is yours.
Okay. An association, an HOA, in their governing documents, it has a traditional 14-day meeting notice. Meeting notice goes out, you hold a traditional HOA election. Does the developer have the ability to change that while under developer control to use the two notice condo? They send out a notice and ask for board members. Okay, they have a deadline. If they have enough candidates, they are using an online system to have elections, but they don't necessarily hold a traditional annual meeting. Does that make sense?
I mean, I think I'm understanding what you're saying. I mean, it's hard to say because I don't know if the developer still has the unilateral right to pass amendments within. You say
It doesn't anymore. He did. It was changed under the developer, but the homeowner board is still following through with this process.
I mean, it's really hard to say without actually reviewing the materials. Generally the law for HOAs is you follow the election process within your governing docs unless you sort of opt out and elect to go a different route. So I'm a little confused as to how, if the developer lacks the unilateral right to amend anything, it has the ability to sit here and change the process midstream, for lack of a better term.
Right. Okay, I understand. Yeah, that makes sense.
Thank you, Melanie. Thanks for elaborating. We appreciate it. Happy New Year.
Happy New Year.
Okay, our next question is budgeting related. We budget for flood insurance each year, which makes up a large part of our budget. Are we required by Florida law to have this flood insurance?
The old famous, everybody wants to drop flood insurance because it's too expensive. I mean, the general obligation of the board of directors is to make sure the property is adequately insured. So, and you have to think, not only when we're talking about flood, or if you're a coastal area, you have to worry about flood there, but you also have to worry about, flood in terms of the issue of just your traditional heavy downpour. I am very loath to recommend to associations to drop any type of insurance, even if it's cost prohibitive, just for the fact that it becomes an easy target if something rather unforeseen happens, that suddenly you don't have that insurance policy in place. Now if you have, I have one association years ago that had a flood insurance premium on a guard shack, and they were in a zone where, if it flooded, it was just highly unlikely, but two, also, the cost of the premium exceeded the cost of replacing the guard shack. And in that instance, that board voted to go away with flood insurance. So I think it depends on, what is that flood insurance? What's it covering? Is it covering the whole property? Again, think about it from a liability standpoint that, we're all concerned about cost, and, insurance is rapidly escalating. I think last year we saw, the norm was, I think, half of the insurers in the state that were property insurers that requested a rate increase of 10%, they were getting it. And there's still a perception within Florida that in the insurance industry that they haven't, I hate to say, turned a profit in years, but they're paying out claims. So we're going to continue to force and see these type of insurance increases. So while it's a tough pill to swallow, unless there's a compelling reason to shed flood insurance, I would be loath to recommend dropping it.
Okay. And remember, all of Shawn's answers today should not be considered official legal advice. This is for educational purposes, and you should consult with your association counsel when necessary. And if you don't have one, I can recommend several for you right now, in fact. Our next question is maintenance related, though not really budget related, but I'm going to read it because I think your answer is going to be really, really quick. Where do you stand on condo associations allowing owners to do construction work without required building permits?
Yeah,
Don't do it.
Yeah, don't do it.
there you go.
I will say that, the bigger issue, not just from the fact that you get people doing unpermitted work, but if you run afoul of the local governmental authority that has permit oversight, they're not going to care about that particular owner more often than not. They're going to tag the association for the violation because, one, it's just quick and easy, and they don't want to get into the minutia of association versus owner. So, don't let owners start building away.
Okay. Our next question is election related. And before I get to it, a week from today, we have an elections course, which is going to offer CE credit for managers, as well as excellent material for all board members of all the different association types. So in the follow-up email that everybody's going to receive from this webinar tomorrow, you'll get a follow-up email. There'll be a direct link to register for that course, which is also free with Allison Hertz from our Palm Beach office. So you'll get that link, but you could also check out our association, our firm calendar at kbrlegal.com, which has all of our January and some of our February offerings already available for you online to register. So with that out of the way, I want to mention now our next question is election related. Is our POA required to hold an election if there are no new candidates and the existing board has already agreed to continue to serve?
Well, I guess the first question would be, what does it mean agree to serve? Did they actually turn in any intents?
Right.
And if they did and nobody else has turned in any intents and the existing board has, then, as long as you're met all the other criteria, again, if you're a POA and you're operating under 720, you got to make sure that you don't have the ability to allow for nominations from the floor that upends it. So again, this is very governing document provided. I will say, also a corollary in the condo, and I just had this issue, is if nobody turns in any intents, including the existing board, then the existing board continues to roll through even though their terms expire. So again, it's kind of hard to say when they say agree to, hopefully they've at least submitted whatever is required to state that they're willing to serve again. Beyond that, it's really governing document driven. I'd have to kind of see the governing documents to make sure that, they just can't will themselves into another term.
Okay. Our next question is one we see quite, that I've seen quite often. This gentleman or this person owns a home in two separate HOAs. One of them votes in elections by mail, and the other requires the vote during the annual meeting with the use of proxies by non-attendees. The question is, in an HOA, can the election for the board even be by mail? Can it be by mail?
So I'm assuming by mail, we're talking the condo style election format. And, there's nothing that prohibits that. If the governing documents are structured that way and the association has gone through, you can follow the condo style election. One of the things that we always joke about as attorneys is that one of these days, somewhere in Florida, they're going to actually harmonize 718 and 720 in some format, at least with election issues. So it doesn't become, condos do this, and then HOAs do this, maybe this, and sometimes this. So again, it's really governing document driven on the HOA side, but I have seen a lot more HOAs moving towards the condo style election, which is, I guess, what we refer to in the vote by mail, just because of the certainty to it, and avoids the chaos at the annual meeting that somebody shows up with nominations from the floor and has in their hands 230 proxies.
Okay. Next question is also election related. Can a sitting president, it doesn't say HOA or condo, it doesn't really matter. Can a sitting president ask for who is running for the election via letters of intent? They were sent into the management company in sealed envelopes. So I guess the question is, can they be sent directly to the board, or does it have to go to a management company? If I'm understanding the question properly.
I mean, I think if what I'm understanding them asking is, I'm kind of surprised that they're sealed. I've never heard of that. I mean, the law generally is that, whatever the requirements are to qualify in a condo, it's very specific. You deliver your notice of intent to the association in advance of the deadline. So at that point, I don't think there's any issue of the president seeing it, because, the election materials are going to be prepped. The notices are going to go out. Those are official records of the association. You've received the intent. I think I would have an issue from just a perception standpoint that it looks like the president may be seeking information sort of surreptitiously to dissuade people. So, in that instance, I think I would rather at least the president would follow the normal process for however you would obtain records. But if, if the information comes in, I don't think there's any issue with any owner seeing it, because you're going to be sending out the ballot that lists all the people who stated an intent to run for the board.
Again, if I'm skipping over questions, it's because they're not on topic. So again, apologies there. If an HOA, this is election related, if an HOA has an election and the notice states voting is from 5 p.m. to 7 p.m. and at 7 p.m. the doors were closed, does the HOA have an obligation to allow the remaining 150 people standing outside to vote?
There's a lot more to that story than that question allows. I'm sort of picturing, Katie bar the door type thing here. But generally you're allowed to turn in your ballot for any election up until the point where you start actually conducting the election, i.e. tallying the ballots. You've made the last call. So it's interesting, and again, I'm sort of going off the facts that it's limited from 5 to 7, which implies that nobody can turn in their ballot in advance. So I have a feeling that one's ripe for some sort of challenge if the facts are what they say they are, because, if you have people outside at 7 o'clock and you haven't started, tallying the ballots and you still haven't made the last call for them, then you may have an issue in terms of disenfranchisement. But once you've already started the election and started tallying the ballots, then, sorry, it was speak now or forever hold your peace. And if you missed that cutoff, that's the end of it. There's kind of a separate issue of, I don't know why 150 people are sitting outside, and was the association keeping people from voting? There's a lot more to that question, and it's something that's very fascinating for sure.
Yeah. Okay, getting to the next question that's on topic here. This is budgeting and maintenance related. We had roof damage from Hurricane Irma and are currently undergoing roof replacements. We settled a claim with the insurance company and paying for the new roof. Is there a sequence of what monies are used? Insurance, reserves, assessments is the question. Can the insurance money be used for other expenditures other than the roof?
Without seeing how the settlement agreement is with the insurance carrier on that, I would be very loath to off the cuff say, use somebody's insurance proceeds for a different matter. The insurer paid out, if they paid out, for example, $5 million on a roof claim, then, you know, if your roof costs $7 million, you'd want to spend all of that money when it comes to obviously the roof. You know, if you're taking insurance funds and using them elsewhere, then you start to, you know, skirt into a strange, interesting world of, you know, whether you, I don't want to call it insurance fraud because I don't think there's an intent there, you know, but how, so again, it's really hard without having that settlement in hand. You know, now if the insurance carrier gives you $5 million for the roof claim and somehow you manage to only do it for 4, you know, then I would recommend talking to your attorney about what to do with those funds, because obviously the attorneys are going to be involved with settling with the insurance carrier. But long story short, if you got the claim and you use all the claim money first, use the insurance fund so you don't have a larger issue down the road of, you know, an improper claim.
Okay. And this is from David. Happy New Year. I just want to thank you for all these great webinars that you offer to condo and HOA associations. Well, thank you for that comment, David. Happy New Year to you and your loved ones as well. We appreciate that and appreciate you very, very much, as everybody showing up today. Thank you very, very much. Our next question is a board member, no, that's, I'm sorry, I'm just trying to get on topic here. Okay, budget related. It is early January 2022 and our condo has never been given monthly amounts or property insurance, and our property insurance is going to increase. We were told to figure 25 to 30% increase from last year when we did our budgets in October 2021. Is this normal? And I guess that's going along the lines of a question that budgets, when you prepare a budget is the association's best guess of what they think might happen, correct?
I mean, it is, you know, you try to use the information you have. And if your insurance agent is saying, you know, budget for a 25, 30% increase, you know, they generally have a good idea of the property insurance market and will have a fairly good idea of where the insurance lies. But it's still not unusual that they may say budget for a 30% increase, and then it comes in and then you realize suddenly it's a 50% increase. You know, so in that type of an instance, you have to make a decision of whether, you know, if it's early in the year, can you amend the budget to address that and build it into the budget? Or are we going to have to look at a potential special assessment? You know, it's unfortunate that a lot of times when you go to do insurances, numbers are just estimates. And so we were talking earlier, you know, about sort of contingency funds. You know, if you get an estimate for that, you may want to talk to the insurance agent and say, look, you know, you may say budget for 30, but should we, you know, set aside 35 just to give ourselves a little wiggle room in case it comes high.
Okay. This one is budgeting related as well, from Paul. What should a board do if it overspends the budget? And you touched upon it a little bit there with special assessments and such. My HOA's annual budget is about 50 grand and they managed to spend about 70.
I mean, the first step would be to figure out how are you missing a budget by, you know, almost 50%. You know, it's not unusual for an association potentially to overspend on a budget. You know, again, it's sort of your best guess. You're taking a look at what the numbers were from the preceding years and trying to forecast into the future. So it's not uncommon in that situation, if your budget's 50,000, that you might spend 52, 55. You know, maybe legal was higher, maybe accounting was higher, maybe, you know, some type of maintenance for common area that the association had went up a bit. But if you're overspending by a factor of, you know, that number, 20,000, literally almost a 50% over budget, you know, really, I hate to say it's, you want to take a hard look at how is the association ending up so far over budget. And if it's routine and it's not a one-off issue, then the board really needs to look at how they're factoring the budget. You know, is this one of those where you're artificially putting assessments low, you know, sort of in order to keep favor and keep position? I've seen it, unfortunately, in 20 years. It happens from time to time. Yeah. And you know, you really need to be going back and building in the budget versus, you know, spend 50 and then come around and assess to get 20. So without having the budget, it's really hard to get an idea of why you're over by 20,000. But in my mind, if you're almost spending 50% more than you're budgeting, somewhere that in that budget planning by the board, they're not adequately addressing the numbers, and that really needs to be some homework as to why they're off by so much.
Okay. This one's a quick one. It's not quite related, but I think it's a one-word answer that you may be able to help with. What DBPR department regulates or oversees condo associations?
There's no such thing for a lawyer as a one-word answer. So that's the Department of Business and Professional Regulation, and then you dump into the, you know, the Florida Division of Condominiums. And so you can have all kinds of fun with the Division of Condominiums in terms of enforcement, in terms of education. But that's your agency.
There you go. And that was that wasn't that many words either. Well done. Nancy, I'm going to have to enable your mic, Nancy Schneider, because there's some numbers here. I'm not able to make sense of them with regards to replacing a seawall. So it's a budget related question. Nancy, can you please unmute yourself and ask your question of Shawn Brown here? You just have to hit unmute and then you can vocalize your question. Going once. Going twice. There you are.
Can you hear me?
We can hear you. Yes. Please go ahead with your questions.
Hi, sorry, I'm in my car, so I wasn't sure how to manage it. So basically, our seawall has to get replaced, and we are allocating the budget per percentage. Like bedroom units pay less than 2-bedroom units because all of our fees are allocated by square footage. However, there's boat slips and they are deeded that are separate, and they have a percentage of ownership too based on the square footage of the boat slips. So the question is regarding the replacement of the seawall, is it just divided by the unit owners, the condo unit owners, or are the boat slips considered additional square footage to be sort of allocated toward the cost of replacing the seawall?
That's one of those where I would have to literally see the documents within it, and because usually in these type of situations, unless you have, if the boat slips are truly like their own independent units, then they would just be an appurtenance to most of these units. Condominium units is what it sounds like, with 1-bedroom and 2-bedroom. And that they wouldn't be considered within a factor. But without having the governing docs and seeing how these boat slips are tied into, and there's an allocation, it's really hard to give you a concrete answer. But my default would be, most of these situations, and they're, an amenity that's pertinent to a unit, and more often than not, it's not factored in a square footage allocation, and that you go off of how the unit square footage is in the declaration.
Okay, so then the seawall, based on what you're saying, for this example, the seawall would be then divided by the number of units of the condos, but then based on the percentage of the square footage, just like all the other, like the HOA fee is.
Yeah, I mean, if it's structured the way you're describing it, then yeah, how you would allocate it would be based, percentage of your obligation under the declaration. So if a 1-1 that's 500 square feet pays X and so forth, and if you assess 2 million, you would just allocate in accordance with the declaration and the schedule there.
Okay, so the boat slip owners don't have any additional fees on that then?
Again, I'd have to see the docs, and if they're not separate units and just an appurtenance to the unit, then there would be no obligation there. I'd have to really see the docs to see how the boat slips are allocated within that declaration.
Okay, all right. Thank you so much. I appreciate
Thanks,
it.
Nancy. Drive safely. Happy New Year. Let's see here. If a budget notice was mailed for a condo association and the date was changed, does a new notice have to go out, or does posting it on site suffice? They also post it on their website. Their documents state that a budget must be mailed 30 days in advance.
I mean, even if that's what is providing, and if you provide the wrong information, I'm a big fan of disclosure, and that, it's much better to err on the side of caution. So if you had the date and it is incorrect, you're off by a day or two, I would always err on the side of resending that notice out as how you've always traditionally done it, versus opening up any potential challenge. It's always easier to spend a couple $100 to just fix a mailing issue and redo it, even if it seems like a pain or it shouldn't be worth it, than it is to just plow it and post it on the community website, post it on the bulletin board, plow forward, and then get somebody who hires an attorney just to make your life miserable, take a shot at blowing up the entire budget, and then you end up spending 5-6 times that in legal fees.
Yeah.
Unless there's a real compelling interest, I just recommend just redo it, save yourself the headache. The cost of mailing is substantially less than it is the cost of having to hire me or have any other attorney to sit there and have to write a letter back explaining why this was allowed.
Okay. Here's one that's election related. Are board members ever allowed to have a business such as a janitorial or similar and bill the association and still be elected to the board and still be on the board?
So we're getting into the fun world of conflicts of interest.
Okay.
That's what I'm guessing we're talking about here. So, you know, again, I'm assuming there's nothing in the docs addressing it, so you can default to the statute. And so it sounds like we're kind of in the condo world with conflicts of interest, you know, and so the issue becomes, what is that level of company? I mean, my first thing would be to, you know, recommend to any association, unless there's an absolutely really compelling reason that, you know, this board member provides a very unique service, try to refrain from hiring, you know, companies that are managed or controlled by any board member. It just leads to headaches. Even if you go through all the requirements and you get it vetted, it just creates its own sense of an issue and becomes obviously a perception issue down the line once, you know, the membership gets riled up and starts saying, well, hey, wait a minute, you know, they're paying the board member. It may be under a perfectly justified contract, but again, unless there's a compelling reason to do so, I recommend not hiring board members to perform services. But if you have no other choice and, you know, this person provides a unique service, then, you know, there is a very specific provision in the statute that addresses conflicts of interest, how you go through and getting it approved and deal with it from that fashion. So I would, you know, go down that road of addressing the conflict, but I would, you know, to me, I would back up beyond that and just look at the larger policy issue of why is an association hiring a board member to do a service? In my experience, no matter who it is, you know, no matter how fair the contract is, no matter how reasonable the terms are, it just never ends well at some point.
Okay. For condominium members here, condo board members, term limits. The question here, I'm going to try to make sense out of this question. It's kind of broken sentences. Term limits for condo members. Over a month, no minutes from annual meetings as of yet. So I guess the question is, what are term limits for condo members? Is there a limit to get the minutes from the annual meeting? Like, is there, I guess, asking, is there a penalty if they don't release minutes from the annual meeting? And are there any problems with the entire board? Again, according to this question, are there any problems with the entire board not living there year round, and in some cases not there at all for almost 2 years, off site for almost 2 years?
Well, I mean, the first one is obviously the statute was changed. So as we said earlier, it's an 8-year term limit for condo board members counting from 2018 forward. So that's the term limit issue there. In terms of offsite, yeah, I mean, you know, as long as you meet the criteria of owning the unit, there's not some other weird eligibility criteria, it's not unusual. I mean, I always like to say that I had this one condominium years ago out in the beach over in Pinellas County where everybody was in Canada year round. They'd come down maybe once here or there. And so the board meetings would generally be me sitting in a lobby with the manager on speakerphone while they were up in Canada all together. So it's not unusual, you know. And in terms of the minutes, you know, if they're failing to maintain official records, that's its own separate issue of, you know, are the minutes not being properly maintained? Are they in existence and not being properly provided when requested? So that gets into the issue of the official records and the owner's right of access to them.
This one's sort of a general statement, maybe asking about your experience of how you've some opinions offered in the past on this. I have an HOA that I'm having a hard time helping them to understand that the docs require that we must have a president, a secretary, and a treasurer, but nobody wants to step up to the presidential spot. Any insight on how we may be able to handle this?
I've never heard of anybody not wanting to be president. Usually there's more people wanting to be. Yeah, I mean, really, it's, you know, if you want to sort of be kind of cruel about it, if there's, you know, 5 people on the board and you get 3 to convene, you could just say like, okay, the guy who didn't show up, call him Joe for convenience. We're going to make Joe the president. Tough, you know, then he can resign from president. I mean, it's unusual. I mean, I don't think I've ever had a situation where somebody did not want to be president in 20 years. I've had situations where, you know, board members have gotten together to strip somebody of the presidency without really telling them and posting the notice in that fashion. But, you know, if nobody's willing to step up, I think there needs to be sort of the attorney and the manager and the board need to have a sort of a discussion about what's the larger structural issue as to why nobody will take it. Are there fears about being named president and being sort of the figurehead of running that association that raise concerns about liability or exposure, anything of that sort? And so I think it really becomes more of sort of a pep talk and trying to talk to the people and saying, what are the concerns? Why doesn't anybody want to be an officer? And then try to assuage them in that fashion.
It's a message from a licensed CAM. I'm the CAM of a COA, and for the last 40 years, the election and budgets have been done in January. Our treasurer has not included the budget correctly, and now the treasurer wants the CAM, this person, to do the reserve schedule. Isn't that the treasurer's duties? Is the question.
I mean, really, in terms of reserves, the obligation is for the board to propose the budget. So, while the treasurer may be the person sort of as the figurehead tasked with doing the numbers, it really should be the entire board working together, hopefully, obviously, with the CAM to sit there and figure out what is the reserve schedule. Do you have the reserve analysis? Do you need to have a reserve analysis? I mean, obviously, unless there's something in the management agreement that says specifically that the manager is preparing this, it's
Right.
the obligation of the association and its board of directors to put forth the budget.
Right. Sounds to me like it's a delegating issue as to what's in that contract with the management company, correct?
It's possible, or it just could be somebody just wants to be, kick the blame to somebody else for making an oversight. Not uncommon in this field.
Really? When offering e-voting, I knew an e-voting question would come up. When offering e-voting, do we need to have specific consent from a homeowner to do said e-voting? Or if we already have an email for owners, can we just use that without any kind of additional consent?
Electronic voting is an opt-in, and that's the way it is. So even if you have emails, just because somebody's giving you the email doesn't automatically say that they're going to be qualified for e-voting. E-voting is designed structurally to be an opt-in format, and the legislature, hasn't seen fit to change that. So remember that the obligation is for the person to consent in writing to say, I want to participate in this electronic voting, and that it's not email voting and you just don't blast it out and they email back yes. It's a very specific structure within the statute about having owners opt into the format.
And that's, similar, you mentioned opting in. I would assume the same thing goes for email. It's kind of like having a resident directory, like in the past, the old print directories. You have to give the owner the ability to opt out of the directory. With email, it's opt in for official association business, correct?
That is correct. It'd be great to just be able to blast an email and vote on everything, but you have to remember electronic voting is not email voting. And if you're in a condo land, I would tell you the division of condos has been explicit on that. We had, like I said, I was just in a webinar with them last month, and they were explicit on that. That remember, electronic voting is not email voting, and is an opt-in requirement.
Opt-in. Okay, and again, just a reminder to everybody, if I'm skipping over your questions, it's because they're not on topic, so it doesn't mean we don't love you. Our next question is budgeting and budgeting insurance related. Our condo insurance policy ends next month on February 28th. The company is leaving the state. We just received a settlement for a suit to replace our clubhouse roof, a lawsuit against insurance company. Are we going to have a problem securing new insurance for our condo, in your opinion, based on the status of what's happening now?
There's always somebody who will insure you. It's just a question of the cost. It goes back to the old, Jerry Maguire, show me the money. It'll be there. Somebody will offer you an insurance policy. You may not like the terms of it. You've got a lawsuit against in a claim, so that's going to pop up and obviously in your loss run report, and it's going to affect the renewal rate. It's obviously a little concerning that insurance carriers leaving the state, and in less than 60 days, you're going to be up for being out without insurance. But in my experience, you will always find someone willing to insure the property. It's just a question of the dollar amount.
And citizens is that dirty word, right?
I mean, Citizens is there, and there's a big push to continually jack the rates of Citizens to try and make it, again, cost prohibitive and induce, private insurers. But as I was mentioning, and we those of you that were on any of our webinars last year on the legislative update where we talked about insurance, one of the big things we're seeing in terms of Florida is this idea that the claims are going through the roof and that the insurers are not able to keep up. And so the Office of Insurance Regulation has been sort of approving almost every massive rate hike that you're seeing. So yeah, I want to say, like, again, half of the insurers in Florida saw double-digit rate hikes, and the state's been approving them left and right because there's a perception, at least in Tallahassee, that the insurers are being whacked by roof claims and other type of property claims, and that the rates need to go up commensurate with the risk and the claims.
Okay. Okay, this person has two questions that are election related and similar but different. What if an existing board member resigns on the eve of the election and no one else is nominated? How would a position like that be filled?
So I guess the first thing would be if it's condo or HOA, so it's really kind of hard to figure that out. But assuming that the board member resigns and there's that vacancy, and you roll through and there's no candidate for it, then the traditional rule is the existing remaining board members determine how to fill that vacancy.
Okay. And what if the existing board member sends a resignation to be effective in 2 months? It's the same person with the question. Is that considered an instantaneous resignation or only valid upon the passage of the 2 months?
I mean, it's really going to depend on the type of association and the governing documents. But generally, and in some associations, you're allowed to extend out, very unique situations, the resignation. And in other associations, you're not allowed to do that. Once you submit a resignation, it's over and done with. So without having more of the governing documents, it's hard to say.
It's kind of like post-dating a check. Okay, our treasurer did not include the numbers for fully funding the budget and only sent out partial funding. Is it still the treasurer's responsibility to perform this task prior to leaving the board? And are we allowed to let the membership know at our next meeting? Should he be calculating, should the treasurer be calculating these numbers, or should we have had a reserve study done prior to the budget?
There's a lot to unpack in that question. I mean, as we were talking on the one earlier, again, it's not just the treasurer's job. I mean, they're sort of the focal point, but it's an obligation of the whole board. If the treasurer has the numbers more often than not, but the whole board's obligation is to go forward with it. The treasurer with the board may be proposing a partial funding, not a full funding, a waiver of reserves. So, part of it would have to be seen what exactly was done in terms of the process of, did the board vote to authorize to send out to the membership a partially funded budget? Did they not include the fully funded numbers? Was that an oversight? Is there something there? So again, without more, it's hard to say, other than understand that, again, it's the board's job to, propose the budget and adopt the budget and send it out to the membership. So as much as we like to pin it on one person, sort of is an overall obligation together.
Okay. And okay, we have about 15 minutes left on the advertised time. So let's, we're going to go through, we have 10 questions in the queue here. I haven't looked to see if they're all on topic, but if they are, we'll take those 10 questions. Anything that comes in from this point on, we may not have the time to get to them. So just keep that in mind, but we'll do the best we can. Let's see here. Elections related from George, an HOA and a condo. When a candidate submits their notice to run, and their along with their one-page summary sheet, allowing any board member, officer, or other owner to have access to this gives them an unfair advantage. They get to see what the other, I guess this is more of a comment than a statement. They get to see what the other candidates wrote and can prepare a response with this information. This person doesn't think that's fair. What do you think about a scenario like that? Is that a good practice?
I mean, again, it's kind of internal board politics, but in my mind, once that notice of intent comes in, it's been opened up, the association received it. In my mind, it's a record of the association that can be obtained. Whether the board member and the candidate want to get into a back and forth, if I'm associating, I'm just saying stay clear of it. I don't see I kind of understand that it's sort of the electioneering issue, for lack of a better term, than an internal political issue. But to me, I don't see the inherent unfairness of if it comes in and anybody makes a request to say, I want to see the records of the association, what's come in. Once it's received, to me, it's a written record of the association that's eligible to be reviewed.
Okay. Here's an interesting one. My HOA, it's budgeting related, sort of. My HOA says they do not give out any financials, just the budget. Is that true? Or I guess this person means, is that allowable? So I guess that like with condos, for instance, on the association website, they post the budget summaries, but not the entire, the monthly summaries, but not the entire monthlies, you know,
Financial.
right. So what do you think about that?
And I mean, again, the financials, the full financials are records of the associations. You know, they may want to just provide snapshot summaries, but as long as the records, the full financials are available and that any owner requesting them can get them in accordance with the process for obtaining official records, I don't have a fundamental issue with it. You know, obviously, you know, when you post summaries and the sort, you know, I think in my mind, again, I'm a big fan of disclosure, noting that it's, you know, this information is summary in nature. If the association is not providing any financials, even upon request of the owner's official record, I think you have a larger issue beyond just the financial information generally in an association that's not allowing access.
Okay. This one seems election related. I'll do my best to decipher it. We have condos and homes. I guess that means condos and HOA. So it must be one of those hybrid communities. One of our condos has tarps on it. I guess tarps on the roof since 2018, 2118 is what it says, but this is not Star Trek. So 2018, and their board president only has 2 board members. Is there anything the master association can do about those tarps, about that?
I mean, that's a very specific question. That's
Very,
part of my review of the documents. You know, I mean, obviously, you know, the first thing that jumps in my mind just from a general standpoint is, you know, if we're here 3 years later and there's still tarps on the roof without any repair underway, I have kind of a really fundamental question about what is the delay in terms of maintenance. I know that, you know, materials and supplies and vendors are tight these days, but at the same time, it shouldn't be, you know, take that long in order to effectuate some type of repair. So, you know, for the master association, it's really going to be document driven. I think, you know, most of the times these situations aren't really addressed within there. And so, yeah, you know, short of launching an all out war on litigation, I think it comes down to reviewing the docs and seeing if there's some sort of pressure point that can be applied.
Okay, makes sense. And we have one question here from something we addressed earlier. Can you please repeat the name of the DBPR department on condos, please?
Florida Division of Condominiums.
Simple enough, 3 words.
4 technically.
Technically, they have a certain contract. Okay, so we don't have any more questions in the queue that are related to elections, budgeting, maintenance, and reserves. Do you want to take a couple of the other ones and see if we can address them, or do you want to?
Yeah, I mean, just like Jeopardy, we'll have a potpourri category.
Final Jeopardy. Okay, we did this one. When an attorney provides a written legal opinion, is there any reason all owners cannot have access to the letter? And there's only 3 questions left. So these are the final 3. So any new questions, you know, since we've covered them all. So please hold off on that. So when an attorney provides a written legal opinion, is there any reason all owners cannot have access to the letter? Example, a board secretary puts excerpts in a Friday update under pressure from owners, but have not released the letter, which had to do with updating something in our community. No confidential other owner info is on the document.
I mean, it really depends on what is the substance of that letter. If it's, you know, in response to, you know, pending or threatened litigation or anything of that sort, then it remains confidential for the duration of it. If it's just an opinion letter, you know, somebody asked me for an opinion about, you know, what are the maintenance obligations of a, you know, certain association? What does the owner versus the association handle in terms of an air conditioning unit in a condo? You know, to me, that's not, there's nothing pending, threatened there. It's an opinion provided to the association, and it should be freely provided, or at least, you know, something that if you want, you can ask the association, hey, I want to see the official records. I want a copy of this letter, and have them at least, you know, quantify and articulate their position of why is this confidential? You know, isn't dealing with some sort of litigation matter or some other, you know, personnel thing that would allow it to be confidential, or is the board just, you know, playing fast and loose with the idea of it's an opinion letter?
Or, you know, that spawns a question from me. This is not from the queue. When you mention personnel, are personnel, like, let's say you have a management team with maintenance workers, the whole 9 yards. And I compare this to like that of public workers in a city for like a university or something where all the salaries are public record. Is stuff like that allowed to be, is that open to all of unit owners to see employee salaries of an association?
I mean, if the association's paying them, then there's certain records, I'm going to quote the exact thing because I want to be very specific on this.
I didn't mean to put you on the spot. It just spawned a thought because I used to be in that boat working for a large scale association.
I like to, address this very specifically because, the idea is that you're not getting, confidential information. That's the core here.
Right.
So, and I want to quote the statute specifically because I know people, the way it comes through is very interesting with the way the statute's worded. And there's been many efforts. So this is the exact wording. Personnel records of an association or management company employee, including but not limited to disciplinary, payroll, health, and insurance records. So these are records that are not protected. And then they try to define it further. Personnel records does not include written employment agreements with an association, employer, management company, or as your point, or budgetary or financial records that indicate the compensation paid. So while you can get, payroll stuff is sort of confidential, personnel records, allows that to get there. What are you paying somebody? It's your assessments.
Okay. Last couple of questions here. Our president sets the meeting times and they don't seem to be convenient for anyone. I don't mean to laugh, but I hear that a lot. I hear that a lot. And ignores what the majority of what the people want. Can anyone demand the president to set a better time?
I mean, it's unfortunate that's kind of common in this field.
Yeah. And I'm not laughing at your situation. I'm just laughing because this comes up so often.
Yeah. I mean, unfortunately, when it comes to board meetings, the board has the flexibility to determine when it is. And, oftentimes the meetings aren't convenient. And, depending upon the size of the community, the meetings aren't going to be convenient for everyone. As somebody, practicing this field, I'm fine with the meetings being at 3, 4 o'clock in the afternoon versus starting at 7:30, even though I understand that most people work. So short of just voicing your displeasure beyond that, I mean, I guess you could launch a recall effort to take out the president, but it's a common issue, and there's you're never going to find a time that's convenient. And as you noted earlier, that's where the technology comes in, is that if the time is inconvenient, if, you're having, these hybrid meetings, we call them, where they're live and in person, but have a Zoom function to it, allowing at least observation, it helps address some of those issues.
Yeah, that's cool. In my old, in one of my previous career moments, we had a closed circuit television station that only reached the units within the gated community, and we would record we wouldn't go live. We didn't go live often, but we would record the board meetings and then play the minutes version of the meeting for everybody on a repeated loop on there. So that was kind of cool. Do management companies, this is kind of an open-ended question, but do management companies usually have a certain contract length of years for condo associations? We're trying to get the contract from ours to see when it expires. They are refusing to give it to us. What can we do?
I mean, that's if you're not, there's a lot there again.
It's a lot there.
Yeah. If you're not being provided with the contract of the association, then you have to wonder, one, what's going on with the official records and why it's not. I mean, a management company contract would be there. There's usually not a consistent length. I've seen 1 year, I've seen 2 years, 3, I've even seen 5 years. So I don't think there's, any specific term where you'd say this is industry standard. I think more often than not, I see 3. And it seems to be where most of these are, but I wouldn't call it an industry standard. They all have their own various cancellation and renewal provisions. I will use an old adage from, growing up in California, being an Oakland A's fan, from the Charlie Finley days of there's no such thing as a bad 1-year contract, as long as you can get out of it.
Okay. Shawn, can you see that last question? It looks like I missed one. And you see that one there?
Maria Lorenzo, I'm a member of the board. 2 apartments were sold in our building. Our attorney repossessed and sold the apartments. They gave us only the maintenance fees in arrears. I would like to get the closing statement to know the details. Is that a right to get that info? So it sounds, again, I can't tell if these were sold at like a foreclosure sale or if these things were sold in some other type of format. You know, it's rather troubling in a way that the attorney repossessed these. I don't know exactly what the background is to that. It's probably, there's an ethical issue there if, you know, you've got an attorney dabbling in the affairs of the client, even if it's a public auction. In terms of, you know, only the maintenance fees and arrears, again, it's hard to know for sure without knowing the structure of the sale. I'm going to go with repossessed, that is some type of foreclosure action. And again, depending upon your documents, that it's what it's going to be. You know, closing statements, I mean, those generally aren't going to be records of the association. You know, the closing statements prepared by the title agent for the benefit of the buyer and the seller in that type of a situation. So in order to get the closing statement, you know, you really have to get into some type of litigation and get some third-party discovery. Otherwise, your best bet is to get a hold of the estoppel and any communication related to that, and maybe that will give you an insight as to why only that certain information was provided.
Okay. Andrew, huh? Interesting. Okay. Well, that's all of our questions for today. Sorry, I was caught off guard here with a text, but Shawn, how can people reach you if they're seeking assistance from K-Bender Rembaum out of your office? And then I'll mention how we can reach the other offices.
You can call my office directly, 813-375-0731, or you can email me, sbrown, like the color, at kbrlegal.com. And if you can't remember any of that, just go to our firm's webpage, kbrlegal.com, and you can pull up my biography there and all my contact information.